One. Hello everyone, my name is Natesh. In this video, we will be discussing why some agreements become void under Indian Contract Act 1872 with special reference to Section 56 and Section 29. To begin with, let us understand the meaning of an agreement and a contract. An agreement is formed when two or more parties are agreed to do or not to do something. However, all agreements are contracts. An agreement becomes a contract only when it's legally enforceable, meaning and it's fulfill all the essential elements like lawful consideration, lawful objective, free consent and certainty. Now, important questions arise. Why do some agreements become void? Some agreements are declared void because they lack essential elements, are impossible to perform, or uncertain in nature. The law does not recognize such agreements because enforcing them would be unfair or impractical. This brings us to more important sections we'll focus on. First, section 56, impossibility. This section deals with agreements that are impossible to perform either from beginning or becoming impossible due to events beyond human control. Such agreements are considered void. Section 29, uncertainty. According to this section, agreements in which the terms are not clear or definite are void. The law requires certainty so that the rights and duties of the parties can be clearly understood. Roadmap of this video. In this video, we will first explain section 56 with meaning, example and case laws, followed by section 29 with illustration and legal implication. Finally, we will conclude with brief comparison key takeaways. Thank you.
Hello everyone, my name is Ashwini Kamat. I am from Chanakya University, currently studying MBA. So today I am going to explain a very important topic which is called agreements involving impossibility. So let us know what is the meaning of impossibility. So to understand the agreements involving impossibility, we must first understand what the law means by impossibility of performance. So under the section 56 of Indian Contract Act, an agreement to do an act which is impossible in itself is a void. This means that if promised act cannot be performed in reality, the agreement has no legal value. So this idea behind this section is very practical. So law does not deal with imagination or fantasy. It deals with what can actually be done. So to prove this, this principle is supported by an important legal maxim, lex non cogit ad impossibilia. It means the law does not compel a person to do something which is impossible. In simple words, the law is reasonable. It does not expect impossible from anyone. So if performance is impossible, in reality, the law itself excuses the parties from performance. Now let us discuss the first type of impossibility, known as initial impossibility. Initial impossibility arises when act agreed upon is impossible right from the very beginning. That is, at the time of making the agreement itself. Such agreements are said to be void from the very start. In these cases, these are non-valid contracts because the basic condition of performance is missing. For example, if a person agrees to perform a magic and bring a dead person back to life, such an agreement is clearly impossible, right? So, similarly, if someone agrees to fly like a bird using supernatural powers, the agreement cannot be performed in reality. And in case of business, consider a company that enters into a contract with a foreign client promising to import and supply a product that is legally banned in India. So at the time of signing the agreements, since the law already prohibits the import of that product, fulfilling the contract is legally impossible from the very beginning. Even if both parties are willingly unaware of the restriction, the agreement is void from the start because the law does not permit such performance. So here, it is important to note that impossibility does not mean difficulty or loss or inconvenience. An agreement does not become a void just because it is hard to perform or result is financial losses. Impossibility must be absolute and real, not merely a commercial or personal difficulty. So from business perspective, this shows that the contract must be based on realistic and achievable obligation. Initial impossibility reminds managers that an agreement must be grounded in reality for it have to be a legal validation. Therefore, initial impossibility makes an agreement void because the law does not recognize promises that cannot be fulfilled in this real world. Thank you.
Good morning everyone, my name is Suhas. I will now explain supervening impossibility and its effect, also known as the doctrine of frustration under section 56 of Indian Contract Act 1872. Supervening impossibility occurs when valid contract is formed but after its formation, performance became impossible due to events beyond the control of the parties. At the think of making, the contract performance was possible, but later circumstances make it impossible or unlawful. One important cause is physical destruction of the subject matter. For example, if a contract is made to use a building for an event and building is destroyed by the fire before its event, the contract cannot be performed. Another cause is a death or incapacity of the essential party. If the contract depends on the personal skill of a person, such as a singer or an artist, and a person dies, becomes incapable, and contract is frustrated. And the third cause is change in law. If new law makes the performance of the contract illegal, the contract automatically comes to an end. The legal effect of supervening impossibility is that contract became void. No party is required to perform further obligation. According to section 65, if any benefit of received before the contract became void, it must be returned. This is known as restitution. In conclusion, supervening impossibility ensures fairness by releasing parties from contracts that cannot be performed due to uncontrollable events. Thank you.
My name is Priyavi. I am studying in MBA section Chanakya University. Involving in uncertainty. Meaning of uncertainty agreements. According to section 29 of Indian Constitution, Indian Contract Act 1872, an agreement is void if its mean is not certain or it is not capable of being made certain. The law requires that the terms of an contract must be clear and definite. If the court cannot understand what exactly the parties agreed to, the agreement cannot be enforced. Types of uncertainties. Uncertainty as the subject matters. For example, I will sell you a car. It is not clear which car, brand, model or a registration number. The contract cannot be decided what property is to be delivered. Second point. Uncertainty as to price. For example, I will sell my house at a responsible price. Responsible price is a subject. Different people may have different ideas of what is responsible price. Uncertainty as to quantity. For example, I will sell you some rice. The word sum does not specify the quantity. Without quantity, performance cannot be measured. Uncertainty as to time. For example, I will deliver the goods someday. Time of performance is completely unclear. Court cannot enforce the timelines.
Hello everyone, I am Nitin Yadav. Today I am going to explain about exceptions to impossibility. Impossibility of performance normally ends a contract, but the law clearly says that not every difficulty or problem is treated as impossibility. There are situations where impossibility is not accepted as a defense. First, commercial hardships. If a contract becomes difficult or less profitable, it is still valid. Business losses are normal risks. For example, if a supplier agrees to sell goods at a fixed price and later profits reduce, he must still perform the contract. Second, increase in costs. A rise in cost of raw material, labor or transportation does not make a contract impossible. For example, if construction costs increase after signing a contract, the builder cannot cancel the agreement. Third, strikeout or lockout. A strike or lockout does not automatically cancel a contract unless the contract specifically allows it. For example, if workers go on strike and goods are delayed, the seller is still responsible. Fourth, self-induced impossibility. If a party creates the impossibility by their own actions, they cannot take its benefit. For example, if a person agrees to perform at an event but accepts another booking at the same time, it's their own fault. So the conclusion is like only true and uncontrollable impossibility discharges a contract. Business difficulties, increased costs, strikes, or personal mistakes do not excuse performance. Thank you.
I am Trisha from Chanakya University. Valid uncertainty, Section 29. Under Section 29 of the Indian Contract Act, agreements that are uncertain generally void. This means if the terms of an agreement are unclear, the law will not enforce it. However, uncertainty is allowed if it can be made certain using an objective standard. This means the agreement itself must provide a clear method to remove the uncertainty. For example, if the agreement says that the price will be fixed according to the market rate on the date of the delivery, it is valid. This becomes market rate can be verified and determined objective. Uncertainty is allowed only when it can be made certain without guesswork. And the next, comparison between impossibility and uncertainty. Coming to impossibility, under Section 9 and under Section 56 deals with situations where the performance of the contract itself become impossible. This may be impossible from the beginning or maybe become impossible later due to events like destructions of subject matter or a change in law. On the other hand, uncertainty under Section 29 exists when the meaning of the term is unclear at the time of the agreement. For example, if the concert hall burns down before the event, the contract becomes impossible to perform. But if someone agrees to sell goods at a fair price without explaining what fair means, the agreement is uncertainty or void. In the both cases, the result is that the contract or agreement becomes void, but for different reasons. Next, Section 56 says that impossibility voids contracts, and Section 29 says that uncertainty voids agreements unless uncertainty can be made certain. And there are similar cases in Taylor versus Caldwell that the contract was held void because performance became impossible when the concert hall was burned or destroyed. In Samuel versus